worked, yours isn't working on the iPads, is that? Did it not pull, did you not get the bill?
I just turned it off and turned it back on.
Oh, is yours working, Terry?
Yeah, except for my operator here.
All right, good morning. This is Senate Health and Welfare. It is January 5th, 2024. And this morning we're going through some reports that we've had back from bills we passed in May or April. So Act 27 is the first one, and we'll go through and listen to Katie McClinn regarding what was in the bill, and then we'll hear from folks who were on the working group, and then we'll move on to the next piece of information. So let's start with that one. Katie, thanks.
You're welcome.
Yeah.
Good morning. Katie McClinn, Office of Legislative Counsel. Let me share my screen and I'll pull up Act 27. We did it. Okay, great. So just to refresh your memory before we jump in and look at the language, the concept that was presented and discussed in the Senate last year was the development of a forensic facility, meaning a facility for individuals who were criminally justice involved, who had a mental health condition or an intellectual disability and a high degree of violence. And the proposal that was brought would convert a unit at the Vermont Psychiatric Care Hospital into the licensure term as a therapeutic community residence. So it would no longer be licensed as a hospital setting. And individuals under the custody of both the commissioners of mental health and of Dale would receive programming and residential care at that facility. The language that you looked at as a Senate and voted out had all of the admission procedures, discharge procedures for both individuals with a mental health condition and with an intellectual disability. If you remember, when it went to the House, they had a different take on what to do with this forensic facility, and there was some disagreement as to whether or not individuals with intellectual disabilities should receive treatment and programming at the forensic facility. So what actually passed in Act 27 is much different from the bill that passed out of the Senate. So all of the language about admission procedures, discharge procedures, that was all sort of stripped out of the bill. And instead what passed is what we have in front of us, Act 27. It has some intent language. It has some rulemaking language to prepare for the eventuality that a forensic facility will come into existence, at least for individuals with a mental health condition. And then a big piece of it was a working group to specifically look at the issue of whether individuals with intellectual disability who otherwise meet the criteria for a forensic facility, if that's the appropriate place for them to receive treatment. And later you'll hear back from the working group as to the results of that work. So that's a pared down bill from what you remember looking at. So we have legislative intent language. This sort of says a lot of what I just said in the overview, but the idea is that by July 1 of this year, the forensic facility would be operational. It's a wing of the existing the existing Vermont Psychiatric Care Hospital that would be relicensed. And then we have language in Section 2 about a CON, Certificate of Need. So this language says that there is no certificate of need required for this particular iteration of a forensic facility. So a forensic facility that is at a unit of the Vermont Psychiatric Care Hospital does not need a CON. It doesn't close the door on requiring a CON on a future forensic facility at a different location. And then we have two pieces of rulemaking. So the first was that by August 1st of this past year, the Commissioner of Mental Health was to file an initial proposed rule with regard to the administration of non-emergency involuntary psychiatric medications to allow their administration at a forensic facility. So that was that the proposed rule would be filed, so that's already in process. And then the second rulemaking requirement on page 2, subsection B, this is more of a direction to begin drafting rules. So by September 1st of this past year, Dale and DMH were to work collaboratively to begin drafting proposed amendments to the therapeutic community residence rule for the purpose of creating a forensic facility. Right now, there's no such thing. So it's amending that licensure category and rule to acknowledge that there would now be a forensic facility and to allow the use of emergency and voluntary procedures. So that's things like seclusion and restraint, both physical restraint and chemical restraint medication, and also the administration of involuntary medication at a forensic facility. So those were required the drafting was required to begin as of September. And then you requested a presentation. So that presentation is to be by February 1st of this year. The AHS is to present information to various committees. First, on a plan for staffing and programming at the forensic facility, including whether any specialized training will be required for staff members and whether any services provided at the forensic facility will be contracted to third parties. Second, whether any additional resources are needed for the operation of the forensic facility. And lastly, an assessment of laws, regulations, rules, and policies governing psychiatric hospitals and therapeutic community residences to determine whether there are any conflicts with serving two populations in the same facility. So that is February 1st. Again, not a report, it's a presentation that the administration comes in.
Procedural question. Why did it pass out of our committee, the Senate, and go to the House, and then all this got changed and we didn't?
Well, the House, it's the same thing that would happen if the bill comes over from the House and we change it, we make changes to it, and then there could be a conference committee, or the committee could agree to, yeah, we got this one back late.
Okay.
So it was either something or nothing.
Okay. Section 5 is a report that you will not see until next year. So this is requiring an annual report for 5 years once the forensic facility opens. This has it drafted as the report coming from both DMH and Dale. So there's kind of a built-in assumption. Well, I shouldn't say that there's a built-in assumption that individuals with intellectual disability will be included, because the therapeutic community residence is a Dale licensure category. So it does make sense either way for Dale to be included on the reporting. But that this report would come into various subject matter committees, and it would contain the average daily census at the forensic facility, including trends over time, the number of individuals waitlisted for the forensic facility, and where these individuals receive treatment or programming while waiting for a bed at the forensic facility, aggregated demographic data about the individuals served at the facility, and an account of the number and types of emergency and voluntary procedures used at the facility. So that would be a 5-year annual report once the forensic facility is open. And
this is still just 9 beds?
this is 9 beds, yes. Yeah.
Yes. So that in this section of the bill, we will pick up later on when we meet, probably jointly with judiciary institutions, afternoon committee, but we'll try and meet with them and hear the report.
Following up on Senator Williams' question, how did we come up with 9? I don't remember.
Oh, we didn't do that.
Oh.
Yeah,
I think that's a unit that's available.
The unit's
Okay.
available.
Yeah, it's a 9-bed unit, so yeah. Okay.
I'm sorry.
No, that's okay. Okay to move on? Okay. So section 6 is the working group. So as you know, there was created a working group on the policies pertaining to individuals with intellectual disabilities who are criminal justice involved. So this working group, its mission is right here. The working group shall assess whether a forensic level of care is needed for individuals with intellectual disability who are charged with a crime of violence against another person, have been determined incompetent to stand trial, or adjudicated not guilty by reason of insanity, and are committed to the custody of the Commissioner of Dale. If it is determined that a forensic level of care is needed, the working group is to propose legislation establishing the process and criteria for committing such individuals to a forensic facility. In developing legislation, the working group shall refer to earlier drafts of this act discussed by the General Assembly in 2023. So they're basing their work on all of the work that's already been done, because we had a draft that was at least a place to start.
Would it be possible, sorry to interrupt, just to refresh all of our memories and just so we're all on the same page to get a definition of forensic level of care? Is that possible?
Yeah, I don't think there is a definition necessarily in the bill, but it refers to, you know, the type of population, that the population is criminally justice involved, either adjudicated not guilty by thank you, or not competent to stand trial. So that's sort of the collection of people. And in the original draft, I'm trying to recall, but it talked about the crime that was committed was a crime of violence, and then there were certain standards of what that meant.
Okay.
I can.
Yeah, that's the
pull up the
Judiciary
language.
Committee, half of it is
Right.
the level of crime, and then our half of it is how do you treat or
Right.
work with folks
Yeah.
in that situation.
Okay.
And if you want the specific language, it varied from draft to draft and, you know, House and Senate, but I can pull up some of the language that was being discussed. You have something more specific to look at.
Great.
Okay. Subsection B is the membership of the working group. If you want me to go through it, I will, but I think maybe I'll just skip
Was
through
it
the
pretty hefty?
membership. It was a large group. Included people with lived experience, people from the administration, people from the judiciary, 4 legislative members. Okay. And then in completing the duties of the working group to the extent feasible, the group is to consult with a psychiatrist or psychologist with experience conducting competency evaluations. Individuals with lived experience of intellectual disability who have previous experience in the criminal justice system or civil commitment system, or both. A family member of individuals with intellectual disability who have experience in the criminal justice system or with competency evaluations. The state's attorney, defender general, commissioner of corrections, state programs standing committee for developmental services. So those individuals weren't on the working group, but they were consulted. And then in terms of the powers and duties of the group was directed to assess the need for a forensic level of care for individuals with an intellectual disability, including the extent to which a forensic facility addresses any unmet needs or gaps in resources for individuals with intellectual disabilities. If the working group determines there is a need for individuals with an intellectual disability to receive programming in a forensic facility, the specific circumstances under which an individual committed to the custody of Dale could be placed in a forensic facility. Any amendments to the specific chapter in Title 18 with regard to civil commitment, including amendments needed to ensure due process prior to and during the commitment process, regardless of whether the working group determines that a need for forensic level care exists. For the roles of Vermont Legal Aid, an ombudsman, or Disability Rights Vermont, and serving individuals with intellectual disabilities who might be placed in a forensic facility. Necessary changes to the corresponding chapter in Title 13, which is the criminal justice title, to changes that are made in Title 18 pertaining to individuals with intellectual disability. And lastly, in subdivision 6, investments, policies, and programmatic options for high-quality community-based supports for at-risk individuals committed to the custody of Dale. Language about who is assisting the group, and then the reporting requirement is subsection E, that by December 1st of last year, the group was to submit a written report, which they've done, with findings and recommendations for legislative action, including proposed legislative language. Subsection F has to do with how the meetings are structured. I'll skip over that. Subsection G is compensation for participation of the members of the group. And then we have a definition of what is a forensic facility. So this was pulled from earlier versions of the bill. A residential facility licensed as a therapeutic community residence for an individual with a mental health condition or intellectual disability, if the General Assembly determines that a commitment to a forensic facility is appropriate for an individual with an intellectual disability. It's a person who is charged with a crime of violence against another person, and the individual is assessed as not competent to stand trial or was adjudicated not guilty by reason of insanity. Person requires treatment or programming within a secure setting for an extended period of time. And that is it. So that is the actual act that was finally passed by both bodies last year.
Thank you. Good. So does it bring back some memories? Yeah, it's complicated, but it's not. It is a complex issue when you start to dive into it. And we'll hear that from.
Were you on the working group?
Yes,
Was it you and Senator Sears?
yes.
Okay.
we were. And then, trying to remember who the two House members were.
Is it Rep Wood?
No.
No.
That was.
Rep
Garofano?
Chapin, was it Representative Chapin?
Yeah, we can look in the report.
Representative Chapin.
Oh, good, okay. All right, so questions for Katie?
Just back to my procedural question. Thank you, Katie.
You're welcome.
You know, everything changed, and occasionally, this is a personal problem, but we get, because of changes and decisions were made, we get hammered by our constituents. You know, I haven't been by this, but how do we find out if it went to a conference committee and changes were made?
Oh, so it's all online. So if you Google, if you go to our webpage and look at Act 27,
Okay,
all the actions on the bill will come up and all the iterations of the bill will come up, whether it's in the
Okay.
House or the Senate. So you have that. And because there were two committees involved, it makes it even a little more complicated.
right, okay, thank you.
In this case, I don't think it went to conference committee.
No.
Last year's a little bit of a blur, especially the end of the session, but
It was quick at the end of the session.
the House gave a proposal and the Senate
We agreed.
you either agreed or you sent back a small
Right.
change. I can't quite remember.
You're right. Okay. Any questions for Katie at this point? So we'll, as we go through I don't know, I forgot what your timeline is today.
I can stay with you until 10.
Okay, that's good. Because we'll have the folks from Dale come in. Is Stuart Schuer coming in here? Is he on Zoom? And Megan Tierney Ward is on Zoom. Can you bring her in? Is Stuart coming in or is she? Yeah.
Megan is on right now.
Okay. So if you're around, we're gonna clear your chair over there. There's a chair that you are sitting in that belongs to Katie.
Sure.
We're gonna clear your chair.
Sorry.
No, that's okay.
Thank you.
And then we'll just, is Megan on? Why don't you welcome? Bring her up in the room. There she is. How are you?
Good morning.
Welcome. Are you going to wait for Stuart to show up, or do you want to begin without him on the report? How do you want to go?
I would love Senator to wait for a couple of minutes for General Counsel to join us, because he's our subject matter expert, and I think he'll be able to add more to the conversation.
Okay, why don't we do that? We'll just take a little breather at this point. If anyone has another question for Katie, she's still here. But so generally what we're looking at is the working group report on Act 27. And Katie, just remind us, what is the context for the working group? What did the working group do overall, not all
All the details. I mean, they sort of had a two-part question. One, should individuals with an intellectual disability and sort of these indicators for violence and criminal justice involvement, is a forensic facility the right treatment place? That's sort of the threshold question. And if the answer is yes, then sort of how do we mechanize that in statute? And what, parameters should be around that?
That's helpful, thanks. Okay. Okay,
Stuart and Megan are both joined.
okay, why don't we put the whole screen up with all them? And Karen Barber's also here from mental health, at Department of Mental Health, that's good. Okay, welcome, Megan and Stuart, why don't you join us? Karen, if you want to join us as well, I know that you were interested in this topic and you were very important on the working group, so you can turn your screens on and say hello.
Good morning. Thanks for having me. Happy to answer any questions.
Stuart, are you there? Not yet. Megan, who's taking the lead on this? Are you going to start us off, or Stuart, so we can maybe get started?
To introduce the topic, Stuart will lead the conversation with his experience as facilitator of the working group.
Okay, so before we all begin this, why don't we introduce ourselves just to refresh you who we are, and maybe Stuart will show up again. He just disappeared. So go ahead, Senator Gulick.
No, I'm just laughing, I'm just giggling.
She wants us.
Oh, we're
to-
sorry.
Yeah,
I'm giggling and I will
Take the
introduce
lead.
myself. Hello, Senator Gulick. I live in Burlington and I am the Chittenden Central District. Nice to see you.
Good morning.
Good morning, Dave Leeds, represent Rutland County, and I live in Proctor.
Ginny Lyons, Chittenden Southeast.
Terry Williams, representing Rutland County, I live in Pullman.
And good morning, I'm Senator Ruth Hardy from the Addison District.
Okay. So Stuart, are you there? Maybe he must be having technical difficulties.
for one thing.
Yeah. So Megan, why don't you start us off with a sort of the big global picture and however you want to proceed.
Thank you. I'm Megan Tierney Ward, and I'm the Deputy Commissioner at the Department of Disabilities, Aging and Independent Living. Here with Stuart Shore, our General Counsel, if he can figure his technical issues. So we're here today to talk to you about the Act 27 Working Committee, which Stuart did chair, and the results of it found in the report, and also to confirm from a department position that we do support this forensic facility in limited circumstances. So that will be outlined with much input from our partners on the pros and the cons, and Stuart's, because of his role in that working group, will be able to walk through what those are and what the committee actually shared through that report. And here he is. What great timing.
Boy, oh boy. Sorry about that. I was having technical difficulties. I was trying to scream as loud as I could, but still no one could hear me. So,
Well, glad you're here. Welcome.
Thank you.
Welcome, Stuart. So I will
Thanks.
hand it off to you, Stuart, if you'd like to introduce the work that you participated in. That would be great.
Absolutely. So I wasn't sure exactly what you wanted me to cover, but I'm happy to give an overview of the work that the working group did starting in June, and then open it up for any questions you may have. I think that the rather lengthy report you received does capture what we discussed during the 4 or 5 months that we met. but let me just go ahead and summarize that for you. So starting in June, as I said.
So I think, here, Stuart,
Yeah.
with apologies for interrupting, however, we don't seem to have the Act 27 report for some reason on our webpage. So it may be helpful for you if you can share your screen. Kiki can give you that permission to share, and then put the report up and scroll through. I know there's a lot of background information, but scroll through and maybe give us the highlights of recommendations and some of the debate that went on. That would be very helpful. I'm familiar with this information, but committee members are not, and we're just refreshing our memories about Act 27 overall.
Sure. Let me just go ahead and pull the report up. I know I just had it up a second ago.
We do have, let's see, we do have it. If you go over on the left side of your web page, you'll see reports due to our committee, and looking to see if it's there. It would be at the bottom under 12.1, and not
There's
seeing it.
also a list of reports and resources.
I couldn't find it there. Did you find it?
I'm scrolling. Yeah.
Madam Chair.
It's I think that I don't have it.
Senator, would it be helpful for me to copy and paste a link directly to it in the chat as well?
No, we don't do chat on our screens, but if you send the report to Kiki, then she will post it for us, and she can share her screen and we can look at it.
Okay, I can share my screen as well. I do have it up if you'd like.
Okay, why don't we do that? You share your screen. And
Sure.
Megan, if you don't mind sending the report to Kiki, that would be great. I know everything is a short notice for this one, so we know it's not fully organized. It's fine.
Thank you. I just sent it.
Okay.
Can you see that now?
Not yet.
Not yet. Okay, let me see.
Did you give him permission to share? Yeah, okay. Here we go.
There you go. Okay.
Okay, just make it about 200% bigger.
All right.
We'll get larger.
Yeah. I'm not as skilled in, we tend to use Microsoft Teams, so I'm just wondering.
It's up where is it? On the right side?
Top, very top, in the middle, very top,
See where it says percent? I can't read it.
The plus and minus.
Right.
there you go.
There we go.
Keep going.
Yeah.
That's good. Whoa, that's great.
Oh, too much? Okay, there we go.
Too big.
How's that?
All
We went through, before you were on the screen, joined us, Katie McClinn of Ledge Council went through the bill and the membership. So we don't really need that, but it would be helpful to look at the work and the report summary, executive summary, and then recommendations.
Certainly. So as I was starting to say, we met beginning in mid-June, and the working group members met a total of 11 times. And we're meeting to discuss the charge in Act 27, which was primarily to assess the need for a forensic facility of care for individuals with an intellectual disability who are criminal justice involved. And more specifically, the working group considered whether there is a need for an alternative to the community-based programming that is the exclusive model available to those individuals with intellectual disability who are, number one, found incompetent to stand trial or adjudicated not guilty by reason of insanity, are a danger of harm to others, and are committed to the custody of the Dale Commissioner under what is known as Act 248. So throughout these meetings, it was reiterated that the facility option could be available, not for every individual committed under Act 248 to the custody of the Commissioner of Dale, but for the very few individuals whose dangerousness posed too great a risk to the public or to the staff supporting them, or had demonstrated a history of elopement from or non-participation in the community-based designated programming that's currently available. So the working group heard from Dale and more specifically Developmental Disability Services staff, the designated agencies, the Department of Corrections, the Vermont Center, the Vermont Crisis Intervention Network, regarding the inadequacy of our current system to meet the needs of this very small subset of individuals in Act 248. The working group also heard from members representing Vermont Legal Aid, the Disability Law Project, the Vermont Developmental Disabilities Council, and Green Mountain Self-Advocates, who opined that a forensic facility is too restrictive and is not appropriate for individuals with intellectual disability, and they expressed concerns that individuals would get stuck in the facility. Instead, those members argued that more resources and funding, for example, for staff and community-based housing, could address this problem in its entirety. So this is all to say that the working group did not reach consensus as to the need for a forensic facility, but nonetheless, 9 of the members believed that there is a need for a facility, while 4 believed that there is not. But notwithstanding that vote, the working group spent a considerable amount of time discussing the programming and protections that would need to be put in place if a facility were to be an option. Those in support of the facility option asserted that existing community-based programming for the most dangerous individuals can be very restrictive and isolating and lack a comprehensive support that the forensic facility will be designed to provide, including on-site psychiatric, nursing, and medical care. Next, while there was general agreement about the need for consistency to the extent feasible in the procedures applied to the commitment of those with intellectual disability and those with mental illness to the custody of the Commissioner of Mental Health, the importance of adequate due process protections, the need for step-down options, there was disagreement as to those details. Specifically, members disagreed as to how to address dangerousness for eligibility for placement in the forensic facility, whether all lower levels of care needed to be exhausted before considering such a placement, and the duration of an order of placing an individual in the forensic facility. So the working group looked at earlier drafts of Act 27 and indicated where consensus was reached and where opinions diverged. Those comments are included more fully in the report. But let me just conclude by saying that the current system of care successfully serves in community-based settings the vast majority of individuals who meet public safety criteria, including those who are justice involved and committed to the Commissioner's custody under Act 248. The forensic facility model would be used only for the most dangerous and should not be an indefinite placement. The working group noted the importance of community-based step-down options and designated agency involvement from the time of placement to discharge from the forensic facility to ensure a smooth transition back to the community. So those are the general areas where we reached consensus. We agreed that there needed to be some modifications to the processes that are laid out in statute. We looked at one of the latest drafts that the legislature looked at prior to removing much of the substance from Act 27, and we commented on that. There was consensus about the need for legal protections and the availability of protection and advocacy level advocacy and support to individuals in the forensic facility. But it really comes down to the nuts and bolts of the language itself and whether the members believed that there were adequate protections in the statute to meet the needs of those individuals. So we did not agree that there was a need, although there was an overwhelming majority of the members who did believe that there was a need, that the Department of Corrections was not an appropriate place to house individuals, even on a temporary basis, as they were awaiting a community-based placement. And the Vermont Crisis Intervention Network noted that there were some individuals who could not and frankly should not be served in a community-based setting, but could be better served in a forensic facility that had all of the wraparound supports that the forensic facility would be designed to provide. So I didn't go through the report itself. I basically jumped around in providing that overview. But
You know, it might be helpful to look at page 5, where
Sure.
the members' opinions diverged and some of the areas
Sure.
that we might identify as consensus and those things that are not.
Sure. So one of the major concerns of the advocates, I believe I mentioned, was the concern that individuals would be placed in this facility and would be stuck in the facility. More specifically, the concern was that when individuals are committed to Act 248 and they're then placed in a community-based programming, they would often need to wait for their annual review for a court to determine whether they should be discharged or whether that custody should continue for another year. So the concern was based on this historical evidence about commitment itself, that if an individual was placed in the forensic facility, they would need to wait for potentially up to a year before a court could review whether that placement was in fact the least restrictive for them. So that was one of the issues that was raised. There was a concern that all lower levels of care should have to be tried and exhausted before considering placement in the forensic facility. Those in support of the forensic facility believed that that was an unreasonable approach, in that the risk of having to exhaust as a precondition to placement in the forensic facility all those lower levels of risk for individuals whose behaviors are known to be violent was too great. And that risk to the public and to the community and to the support staff providing the supports to that individual in the community were too great. And therefore, there would need to be, there were certainly circumstances under which a person should not, the state should not have to exhaust all lower levels when it was clear that the individual presented that level of harm or level of risk of harm. So that was one issue. The second issue, and the second bullet up here, to be considered dangerous, the advocates who opposed the use of the forensic facility for individuals with intellectual disability said that there should be repeated evidence or evidence of repeated dangerousness and not merely reliance on the conduct that led to the individual's commitment to the custody of the Dale Commissioner. So those individuals suggested that if an individual had been charged, for example, with sexual assault, and had subsequently been deemed incompetent to stand trial on those charges, that it would not be sufficient for the department to rely merely on the facts underlying that charge to argue that the person should be placed in the forensic facility because they were too much of a risk of harm, but rather there should be evidence of repeated dangerousness before that person could be considered eligible for placement in the facility. Again, that others in the group disagreed that those criteria would need to be met before considering placement in the facility. Again, when someone's conduct is so egregious that through expert testimony, for example, could be shown that it would present a risk of harm to others, that requiring repeated evidence of dangerousness would be an unreasonable ask. And then finally, the area in which some of the members diverged was the orders themselves, the orders of placing an individual into the forensic facility. The advocates believed that the orders from the court should be for a duration of no more than 90 days. So an initial placement of the facility into the facility should be good for 90 days, could be renewed and must be reviewed every 90 days thereafter. In an effort to align the processes between those with intellectual disabilities and those with mental illness, as set forth in 18 VSA Chapter 181, it was the department's position and the position of some others that the initial placement could be for a period of 90 days, but once returning to the court, that order could last and could be extended for a period of up to 1 year. Now that would not preclude the termination of that order at a point earlier in time, but to align once again with the mental health processes, the department's position would be that that initial order be for 90 days and then could be extended for up to 1 year. So these are the minutia of the criteria that we would certainly like to discuss in greater length when a bill is introduced. However, those were the areas where we did not come to full agreement.
So, yeah, and so the discussion was a long discussion over the whole period of how many months, all the 11 meetings, and seemed to go forward 2 steps or forward 1 and back 2, and then forward 2 and back 1. It's a difficult conversation. There's no question about it. The last area that you mentioned was a kind of 2 things. One, I just sent Kiki a short page on Act 248 so that there's some clarity around what that means. That'll be posted on our webpage. It relates to civil commitment for folks who are in the custody of Dale. The other issue is the similarity between how folks are treated, or lack of similarity, or is there continuity between how folks with mental health issues are handled versus those with intellectual disabilities. And Stuart, I know that Karen Barber is also here with us, and maybe that we could have just a short discussion about the differences between how mental health patients are dealt with when they're in the criminal justice, criminally involved system.
Mm-hmm.
Can we would you mind doing that with Karen?
No, I think that's a great idea, Senator. Before Karen jumps in, I did just want to mention that one of the main differences between the 2 populations is that individuals come into Act 248 currently through the criminal court exclusively, and there is no right for an individual or interested party to petition the court to have that individual committed. Some of you may remember that years ago, that was the structure of Act 248, was to allow interested persons to seek the commitment of an individual to the custody of the Dale Commissioner. But currently, the only way for an individual to currently come in to the Commissioner's custody at Dale under Act 248 is if they are charged with a crime, they are deemed incompetent to stand trial for that crime, or are found not guilty by reason of insanity. And then the court would request a competency evaluation. If the individual is found to be incompetent, for example, there would then be a commitment hearing, and the court, and only the criminal court, would be able to place that individual into the Commissioner's custody. Thereafter, another court, the family division, would be reviewing those commitments and continued commitments to determine whether it remained appropriate for that person to be committed. So that's one major difference, and I guess I'll turn it over to Karen to talk about how individuals are treated in the mental health world.
My question is, do you want to leave this report up, or will we come back to it, or you want to? Whatever
you prefer. I think I've covered.
I'll have you and Karen up on the screen along with Megan. Be good.
Okay. All right. I'll stop sharing then. There we go.
All right. Great. Karen, I know that you may not have anticipated this question, but can you give us a response?
Sure, happy to. So for the record, Karen Barber, General Counsel of the Department of Mental Health. I think there are a couple big differences between the way people come into the mental health system and the way people come into the Act 248 system. As Stuart alluded to, Act 248 only comes through the criminal court in DMH world, you can come in either through the civil court or the criminal court. But if you do come in through the criminal court, if you remain in our custody, you ultimately get switched over to the family court. So as Stuart also kind of talked about, initial commitment orders out of the criminal court are for 90 days. And the court only has jurisdiction over that individual for mental health treatment for 90 days. At that point, it goes to the family court. And after that, the orders are for up to a year and the case remains in family court. Most of our statutes live in Title 18, right? Title 13, the criminal title refers to Title 18, but all of the standards for someone to come into our custody, remain in our custody, be medicated, all of those things, those live in Title 18.
And then we're talking about mental health?
Yes.
We're talking now about mental health. Thank you.
Yes, about mental health. Yeah, people coming into
some clarity of what is included in Title 18 and what for mental health versus intellectual disabilities. That's very important to us.
Yes.
Just to understand what do we need to do.
Yes. That's why when Katie kind of briefly went over the forensic bill, what you saw, a lot of the language refers to changes, at least in the DMH section, to changes to Title 18, because that's where most of our stuff lives. And so we needed to make changes to Title 18 to to do that. I would say one of the other biggest things, the differences between DMH and jail, is that we have a locked residential. We do have a locked setting for individuals who require a higher level of care in a secure setting who don't need hospital level of care. And that's the Middlesex. Well, that was Middlesex. Right now it's River Valley, opened in July of this year, 16 beds. So I would say DMH has a much more structured system, right? We have the highest level, which is hospitalization. Then we have the secure residential, which is what we call our hardware secure. So it means the doors are locked. Then we have a series of residentials that are staff secure. So staff 24/7, but people can leave. And then we have pure. So we have, we do have a locked facility, which is unlike Dale. So I would say those are probably two of the biggest. The other thing I would kind of note is that when someone, as I think Stuart kind of alluded to, if someone comes into our system after that initial 90 days, the criminal court order, now they're on a family court order that can be up to a year. But by statute, at any time, the individual can say, I don't think that the state can meet the burden anymore, and ask for the court to review. And DMH has the burden to prove that they still remain a person in need of treatment. Likewise, anytime our clinicians are telling us this person no longer needs this level of care, our job is to discharge them to a lower level of care. So we always have the requirement to serve people in the least restrictive settings. They also maintain their representation through the Legal Aid Mental Health Law Project. So they always have an attorney that they can call if they, throughout the whole process, whenever they're under our care and custody, if they want to contest the fact that they're meeting standard. I think those are some of the biggest.
Thank you for that. That's very helpful. And Stuart, did you want to add anything further on that, or Megan?
I was just going to add one thing, that when individuals that at the commitment hearing for individuals with intellectual disability, they too have representation. I know there was some question as to whether that existed. The statute does provide for legal aid to be available to represent the individuals at that commitment hearing. So they do have that representation at the time of the initial commitment in the criminal division, as well as during the judicial reviews, which are held more or less within 1 year, each year thereafter.
Okay, thank you.
Sure.
Hold on. Megan, did you want to add anything there from your perspective?
No, thank you, Senator.
Okay, good. All right. So what we're seeing is that mental health folks with mental health issues have many options within the court system and outside of the court system, community-based services, and Dale folks who are criminal justice involved may have fewer options. But if someone has committed a serious crime, then we would, I think one thing that we heard very loud and clear in the meetings was prison isn't the right place for these people, for folks who have intellectual disabilities. I think we heard that. And so what we did here is that we need to have an appropriate venue and services for folks with intellectual disabilities. So it's kind of that's the broadest way we can look at it. Okay.
Senator, the one thing I would add, Senator, is that just to keep in mind that individuals with intellectual disabilities who are criminal justice involved but not competent or found not guilty by reason of insanity are not going to be incarcerated as a result of that crime, but they would be potentially held in jail on pre-trial detention or pending the outcome of a competency evaluation. So that's the point at which there's a concern that placement in jail in corrections custody is not appropriate as Dale and his community partners work to develop the best community-based programming that it can, which in many cases may not be suitable to meet the needs of those most dangerous individuals.
Yes.
I would just also, this is Megan, I would also just add that what's really important here is the therapeutic nature of this short-term placement as well, to help make that transition to a community-based plan as successful as possible. So we want folks who have gone through a traumatic experience and to have as much stabilization as possible to make that work well.
A lot of gray areas. Senator Hardy has a question.
Okay, I think I need to back up for a little bit to figure out exactly what the problem is we're trying to solve, because last year, so what are we trying to determine whether or not people with intellectual disabilities should go into this 9-bed facility, should be allowed in the 9-bed facility? Will the 9-bed facility, is it happening? And the only question is, should people with intellectual disabilities be served there? Or is the question, should this 9-bed facility happen at all?
Okay, the facility question itself is a separate question. So we are going to confront that. We have a bill on the forensic facility. So do we build a secure facility for folks with intellectual or mental health? Well,
this 9-bed thing already exists. It's already been, it's a physically, it physically happens.
It's going to be a physical place.
Right, so the 9-bed facility is part of something that's already in existence, right?
Not in existence yet. Wait, where is it right now? Because we decided to do it, and so, yeah. Katie, do you want to help us out with that one?
Sure. The legislation that was passed last year anticipates that it is happening July 1, 2024.
That's what I thought. So it is happening,
but it isn't.
The question is, who's going to go there? Is it going to be both people with mental health and both DMH and Dale people essentially, or is it just going to be DMH? Is that the problem we're trying to solve? I know that's an oversimplification, but that's what I need right now.
If I may,
you want to answer? I see you ready. Go ahead, and Karen, both of them answered. Got my own answer.
Yes, that is essentially the question that this working group was asked to decide, whether it would be appropriate for individuals or a subset of the individuals placed in Act 248 to be eligible for some of those 9 beds. But the plan is for those beds to also be available for people with mental illness who are in the commission.
Okay.
But in a larger sense.
Go ahead, Karen. Go ahead.
Sorry,
Karen, go ahead.
So there are 9 beds currently at VPCH, right? Those are not, there are 25 beds total at VPCH, right? Those 9 of those beds aren't free right now, right? They're being used for hospitals. So there's a lot that needs to happen in order for the 9 beds to actually open as a forensic unit, including new rules that need to be passed, right? So there's also no mechanism right now for someone to actually go into a forensic facility all of that stuff was taken out of the bill. So there's the concept of it, but there's actually no legal mechanism to put them there. So I just want to be careful that it's not like July 1, all of a sudden it can open. A lot of work has to happen and statutes need to change in order for it even to be able to open as a facility, just to kind of clarify that.
Okay, so in order for it to be able to open for anybody, we need to do some work in the statutes. And then the other central question is who's going to go there? Is it going to include people with developmental disabilities who are just as involved? Is that right?
Yes.
Okay. I'm just trying, this gets very cloudy for us who are not experts. And so having it broken down to what is the problem we're trying to solve is helpful for me. Thank you.
So this is the same problem we were trying to solve with the, when we did the legislation, and it's
Exactly.
no, and it's not, it is not. It gets cloudier and cloudier the more we go on. So, this is our first look at this report. We will come back to this issue. Obviously, we're going to need to do that. And the recommendations that were made, albeit they're not that explicit, but they're, you know, there's the pros and cons of each one that you went through on page 5 and talked about the concerns that folks have about how long people stay, what community services should be available before they are committed to a secure forensic facility, and so on. All those questions are things we're going to have to confront and hear, period. Got a lot to do. Any other questions on this topic? Because we want to move on to competency, but I want to make sure that we've started to get our feet on the ground just a little bit.
This may have been covered, and I apologize if I missed it,
No,
but so currently folks with developmental disabilities who are just as involved are in the prison system.
Stuart, do you want to talk about where folks who are criminally involved with intellectual disabilities are within either jail for pretrial services or in the prison system or in the community, and what types of community support they have?
Sure. So individuals who are placed in Act 248 are placed there because they meet the criteria in statute. They have an intellectual disability. They present a danger of harm as defined in statute, and there is designated programming that the commissioner has available to meet their needs. So when an individual is placed in Act 248, the only option for them currently is to be placed in the community. They are placed in a home, maybe in a neighborhood. It may be more remote, and there is oftentimes 2-on-1, 3-on-1 staffing, and a vast majority of those individuals receive the programming that they need without incident, even though they are in fact a danger, but they're not necessarily trying to elope from their programming and committing new crimes out in the community. They're not assaulting their staff. But when we have individuals who are in fact assaulting their staff or repeatedly eloping from the program, and staff doesn't have the ability to put hands on them to bring them back, there is no other option but that community-based option. So if they elope and they commit a new crime, they may be arrested. They may then be taken into corrections custody and held in jail, while perhaps a new competency evaluation is conducted to determine whether they could be tried on that new crime. So it often takes time to build this program. There's no off-the-shelf program for individuals with intellectual disability. It has to be tailored to their specific needs. So if they're charged with the initial crime and they're held, they have to be held in custody. And then they're placed in a program where they may remain or they may try to elope.
Thank you.
That helps.
Thank you.
Yeah, all of these questions and answers help a lot. Any other questions today? Okay. Well, you know, we're getting a flavor of judiciary and sort of defining our role and what we have to do here. So this is extremely helpful. Greatly appreciate your time. And the work that you all did, and I know there are people in the room who worked very hard on the working group itself, and the just real significant work, very much, very well done, very much appreciated. So, and we'll hear from folks as we go ahead. So is there anything else on this report before we jump into competency issues? Okay. So Karen, you're here and available. We were talking about the competency restoration report. We do not have access to our legislative council today to look at the bill that was passed. I think it was Act 28. And so I might prevail on you a little bit to give us the background for how we got here, and then to talk briefly about the competency restoration report that you have. And just to say that this one in particular came out of the work that we did between on the Mental Health Judiciary Council with the court. So the Supreme Court put together a council, and there's kind of the Chief Justice is working on a national level with this, and I was fortunate enough to be included in that. So there's a lot of work going on. This is one subcommittee. Competency was one subcommittee, and competency restoration was something that was in Act 28, asking Department of Mental Health to come back and talk with us about, can someone be restored to competency, and if so, would we have a program in the state? So I don't, Karen, you take over and,
sure,
and share with us a little bit.
Yeah, happy to. Yes, so as most of you know, Act 28, which was S91, I believe last year, made some really fundamental changes to how we look at competency.
You better say your name for the record.
Oh,
Excuse
I'm
me.
sorry. For the
Go
record,
ahead.
Karen Barber, General Counsel for DMH.
Thank you.
Yes, so Act 28 made some really fundamental changes to how we look at competency and sanity in Vermont. And as part of that conversation, we talked a little bit about competency restoration. Most states have competency restoration programs. We are one of the few that doesn't. They really vary across the country as to what they look like, what crimes they target, where they are located. There's not a lot of continuity between the different states. So one of the things we were asked to look at is whether or not it made sense to have a competency restoration program. And why is that important? In Vermont, if someone is found incompetent, it really depends what happens to them, right? Because you have a constitutional right, the Sixth Amendment, to a jury trial, right? And you have to be competent to go to trial. So competency is not a clinical term, it's a legal term. It means, can you participate in the court process? Can you communicate with your attorney? Can you participate in your defense? It's a threshold to getting into court. If you're not competent, your case can't proceed. So it essentially stops the case if someone is found incompetent. And in Vermont, right now, that's kind of where it ends. There are lots of reasons you could be incompetent. It could be mental illness. It could be substance use. It could be an intellectual or developmental disability. It could be a TBI. It could be dementia. So what happens kind of depends on that, and also your clinical need, right? So if you are found incompetent and you have a mental illness, you may or may not go into the Department of Mental Health custody. It depends, right? You still have to meet the legal threshold to be a person in need of treatment. If the goal is to have someone receive hospital level of care, they need to meet hospital level of care, right? They can't just go into the hospital unless they meet that clinical level of care. In the community, they can't go into our locked residential, River Valley, unless that's the least restrictive setting. So again, our obligation to serve people in the least restrictive setting stands. So sometimes there's this idea that if someone is found incompetent and they're dangerous, they're going to be locked somewhere. And that's not necessarily the case. It really depends on their treatment. If someone is in Dale's custody, I think what you heard is they may be on an Act 248 order, but there is no locked setting for them to go to. If it's substance use or some other things, they're likely just going to go back out into the community and hopefully receive services there. So I think what we were trying to tease out is that there's really inconsistent results when someone's incompetent. And does it make sense to think about a competency restoration program so that some of those folks are able to continue on through the court system? I think one of the things to remember is competency restoration is not a way to punish people who are mentally ill or developmentally disabled or any of those things, right? People have a right to a jury trial. And I kind of look at it, and I know we had a Deputy Commissioner, Morning Fox, who used to testify on this years ago and talked about it as kind of reverse discrimination, right? If someone's found not competent because of mental illness, they're presumed to be guilty. And that's kind of sometimes how we look at it. And that's not actually the case, right? It may be that people want to be restored to competency so that they can prove that they are innocent. So it's really allowing them the ability to participate in the court system. And that's why competency restoration is important. So we were tasked with looking at it. So what I did was try to pull together some experts to think about, if we were doing this, what would it look like? What does the literature say? So I worked primarily with two individuals with really relevant clinical experience. First was Dr. Gregory Tomasulo, who's a licensed psychologist, and he's also the Director of Psychology and Recovery Services at VPCH. So he's really familiar with the Vermont system. We do treat a lot of individuals with contact with the forensic system who are not competent at the hospital, so he really had that knowledge base. And I worked with Dr. Keelan Garvey, who's the Director of Forensic Psychology within Novotel Telepsychiatry. She provides forensic services all over the country, which gives her kind of a unique perspective. She's also on faculty at Brown and works a lot with the forensic psychiatry residency program. So she was able to bring kind of more of a national perspective. And then we also worked with Dr. Simi Robin, who I think most of you know. She's the executive or medical director at the Howard Center, but more importantly, is on staff at Yale and is very familiar with their competency restoration and forensic programs. And so she really was able to bring the community perspective. So we looked at first we looked at the clinical literature. What does it say? And if you look at it, there is a high percentage of folks that can be restored to competency if they receive quality treatment and restoration services. One study found up to 81% of mentally ill offenders who were incompetent to stand trial initially were able to be restored. Involuntary medication is often a key component of restoration. One report found that with medication, rates of competency were 74 to 77%. So there's a pretty high percentage of folks with mental illness that can be restored. Intellectual disabilities require different programming. There is a program called the Slater Method, which has been shown to have good results. It works best for individuals with IQs of 63.5 and higher. And one study found that individuals who received the Slater Method versus other methods were restored at much higher rates, 61% to 16%. So there is literature, clinical literature, supporting competency restoration's efficacy for both those with mental illness and those with intellectual disabilities. So we kind of looked at that to kind of look, does it work? Is it working in other places? And then
Karen,
yes.
Karen, to interrupt deliberately, we do have the report on our webpage, and I'm looking at page 11 that describes the Slater Method and includes the data that you have. So I just want the committee to know it's there, and that we'll follow along. We'll keep it up on our pages, and we'll follow along with you. So go ahead.
Sure. Perfect. Yes.
Yeah, that's great. Okay.
Yes, I'm just going to do very high level because I know we don't have a lot of time.
That's fine. That's fine.
Okay.
Yes. But we will come back to this. Have no fear.
Perfect. So the other two things we really focused on were two reports that were done on the national level, because as I said, competency restoration is taking place in most states. It's very varied the way it happens. And so there were two different kind of national groups that looked at it and said, it's not working very effectively. Here are some best practices. So the first we looked at was a 2020 report from the Council of State Governments Justice Center, which was called Just and Well, Rethinking How States Approach Competency to Stand Trial. And all of this is in the report, but basically their idea was to rethink competency restoration and to use it really only when there was a compelling state interest to restore competency, not just everyone goes through competency restoration, but instead be much more focused about who goes through it and focus smaller cases on dismissal or diversion programs. So they suggested 10 key strategies and to do that. And a lot of it focused on education and training, community supports. They really focused on limiting competency restoration to cases that aren't appropriate for dismissal or diversion, conduct evaluations and restoration in the community whenever possible, and provide high quality and equitable evaluation and restoration services. And that's kind of the key, I think. Some competency restoration programs only focus on education. Who's your attorney? Who's the judge? What is the court system? And it kind of lacks the clinical component. And some are just clinical, but they don't really teach them about the court system. A really high quality best practice program does both. In July 2021, the National Judicial Task Force, which is made up of Supreme Court justices from all over the country, created a report called Leading Reform, Competence to Stand Trial Systems, and they published it as a resource to state courts. And as with the Council of State Governments, they saw a benefit in competency restoration, but stressed the importance of being thoughtful and purposeful about how it takes place. And so they built upon the Council of State Governments recommendations, but made some really concrete best practices, which is a lot of what our recommendations are based off of. So again, focus on diversion whenever possible. They actually suggested restricting which cases are even referred for competency evaluations, developing alternative competency evaluation sites like the community. I think it's important to note that unlike Vermont, in most states, competency evals are done in inpatient hospitals, which is often why people are waiting so long for evaluations and competency restoration, because they're waiting for beds. In Vermont, there's always been a focus on providing community services. The vast majority of our competency evaluations take place in the community. They also recommended develop alternative restoration sites like in the community, revising protocols, developing and imposing rational timelines. When we were reviewing some of the lawsuits across the country around competency restoration were about those timelines, where someone could actually be waiting to be restored longer than they would have served if they had just been found guilty. So it's important to have real established timelines around it. Training, recruitment, and retention of staff is really important. They also really stressed using data and then developing robust community-based treatment and supports for diversion and reentry. So those are all the things we kind of looked at to think about what we could do in Vermont. I think, as I said earlier, I think we're in a really good position to do this because we're starting fresh. We get to start from the ground up and design a program, if the legislature wants one, that's really designed on best practices, on clinical research. Change is hard, right? And a lot of what those two reports are focusing on is how to already existing competency restoration programs change to become better and more effective. We're at an advantage because we don't have one, so we can create one from the ground up. And again, we are far ahead of other states in that we do a lot of community-based work already. So we're already kind of ahead of the curve in that. So we had a list of several recommendations that we think are important for a competency restoration program. Again, really pulling from the best practices we saw. We think that Vermont should limit competency restoration to serious crimes and for those that are inappropriate for dismissal or diversion. These are mostly felonies, but we do have some individuals who are kind of chronically committing misdemeanors, who we may have tried diversion or treatment and it's not working. And so those may be individuals that the legislature wants to think about possibly including. We think that you need to conduct evaluations and restoration in the most appropriate sites. That could be a healthcare setting like a hospital or secure residential. It could be in DOC, or it could be fully in the community. We think you need to develop high quality and equitable evaluations in restoration services. Again, we think it's really important, and everything we read made clear that you need to have both clinical and educational, and you really need to focus on making sure it's high quality. We think it's essential to develop and impose rational timelines, that someone can't just be committed to be restored for an indefinite period, that there should be checks and balances, that there should be clear timelines, and that people should have representation at every step of the way. That we should use data to inform decision-making and system improvements. And again, that focus on clinical programming, offer a mix of educational and clinical programming, provide high quality. We do think that we need to talk about the use of involuntary medications. The literature really supports it as something that's oftentimes essential. There's a couple different, there's a whole section on that. It's called the CEL standard. There was a US Supreme Court case about the use of involuntary medications for competency restoration, and it sets out some criteria, which is different than our current criteria for folks. And so we think we really need to look at that and think about, does there need to be a different standard, or at some point a different standard for folks who need involuntary medication for competency restoration? We think it's really important. Yes.
So Karen, right, you're hitting a lot of the areas, you're hitting the recommendations, which is important. Is there a page in the report, or a set of pages in the report, where we can actually see those recommendations? Because I'm looking through and I see a lot of information, but not as...
Yeah, if you look at the executive summary, it's kind of summarized there.
So it's only in the executive.
Is this a 796 page report?
It breaks it out throughout the report.
Page report, right? Now, we've all read it thoroughly and memorized it. And there's also the program design is probably important.
Yeah.
There are a couple of questions that the committee has. I'm just going to ask you briefly, and then we'll get those questions. But are there a set of legislative recommendations or legislative language that you can help us with that would begin to elaborate what we need to do, whether it's through further analysis, or, because I looked at the budget there. I mean, the low cost is a little over 2 million, and then the higher cost program is 4 million. Those are ongoing costs. So anyway, I'll leave that, and I will turn to Senator Gulick, who has a question, and then Senator Weeks will also have a question.
No.
You don't have a question, okay.
I was just wondering if you could give us a sense of what a timeline would look like. You mentioned a timeline, and that was, I've been thinking about that. What do other states do in terms of a timeline for restoration?
It really varies. When we were talking to our clinical folks about what we thought made sense, we were talking about reevaluations every 90 to 120 days may make sense. One of the key points is to have high quality evaluations and reevaluations, right? So being able, and have part of the evaluations being, can the person be restored? If they can, what's a reasonable timeline? And if they say 120 days and we're at the 120 days, do they think there's an amount of time that could get them there? Or at that point, do they think it's not? So kind of changing how we do competency evals to think about those things. So having those be clinically based, having kind of thresholds, but it being clinically based.
Thank you.
Senator Williams. You said there were 81% were actually restored to competency. For what? To stand trial?
Yes. Yes, there's various studies, right, with various percentages, but they range around that like 75 to 82% range, what we found.
Okay.
For mental illness, it is a bit lower for the Slater method. I was at this about 60%.
What states have competency restoration for folks with intellectual disabilities?
I do not know that off the top of my head.
Thank you. Okay. So we're only talking here about mental health issues. And then you were talking at the end about some involuntary medication, which would restore someone to competency. And how frequently is that utilized in other states, and under what conditions, for which crimes, for example?
So again, it depends by state. There really is no overall consensus. What there is consensus about is that medication is often a very key component of competency restoration. You know, frankly, it's often an important component of a lot of treatment, although most of the time people are taking medications voluntarily. And often, you know, there just may be, sometimes, you know, people don't want to be restored, or there's a reason they don't want to take medication, right? So in Vermont, we have, in a lot of states, if you are involuntarily committed for mental health treatment, that includes medication, right? You just can get medicated if clinically they feel that's appropriate. Or there's an administrative process where if there's 2 psychiatrists that agree that you need medication, you get it. You don't go through the court. Vermont is fairly unique in that we have to go back to court, and the court makes medical decisions. You know, we will have cases where we will have a psychiatrist go to court and say, I think this person needs this dose. And the judge says, I think they need this dose, right? And so it's a little different system. So overall, Vermont just looks different from a lot of other states in terms of the way we do medication. So we have a pretty high standard for when someone gets medicated over and above when they come involuntarily into our custody. And so we do have folks that sometimes kind of are not as treated as they could have been because we can't meet the threshold to get them medicated. They choose not to take medication, or they choose to take it at a lower dose than maybe their psychiatrist thinks is clinically indicated. There was a Supreme Court case called the Cell case on this, because a lot of states, again, do use this. And basically it set out some standards, and now I have to go to my page of the report, about what the court should be looking at when making a determination about whether or not someone can be involuntarily medicated for competency restoration. And a lot of that is around kind of the state's interest. Okay, here we go. Is there an important governmental interest at stake? So they're talking about the most serious crimes. They're not talking about someone who's committing just a misdemeanor. One of the first things you're looking at is, what's the governmental interest at stake? Did the defendant commit a serious crime? Is there a substantial likelihood that involuntary medication will restore the defendant's competency and do so without causing side effects that will significantly interfere with the defendant's ability to assist counsel? Is involuntary medication the least intrusive treatment for restoration? And is the proposed medication medically appropriate? So that's a different standard, right, than we use for people civilly committed. And we don't think it should be the same, right, necessarily for folks that are civilly committed, because you can't do the same analysis, right? We're not looking at, have they committed a crime? But we do think that it makes sense to have conversations about whether or not there needs to be some balance and maybe some different rules or additional rules for folks that are going through competency restoration. It's possible to restore people to competency without the use of medication, but it could take a lot longer. It may not be as effective. So that's one of the tools that most states use.
Thank you. We have one more question from Senator Williams, and then I think what we'll do is we're going to come to some closure on this one, and we will invite you back as we take further steps to understand what we might be able to do legislatively. There's a lot here, but we probably should do something. So we'll be in touch with that one. Go ahead.
I'm not going to quote you, I'll paraphrase, but I think you said if there's a medication change, it has to go back to the courts for that determination. How are they qualified to make that decision?
So if there's a medication change, that's involuntary. So if the person consents, we can change medication. But if they don't consent, what happens is we provide expert testimony about what we think. We have their treating physician come in. And then often, legal aid can hire their own independent psychiatrist who may disagree. And sometimes the court just uses its best judgment to make a decision.
It's a slow process, and it's something we may be able to look at going forward.
Thank you.
Karen, thank you so much for being with us for both topics this morning. It opens up complexity that this committee is less familiar with, and we'll come back to it. We will come back to it going forward. I appreciate your time.
Thank you for having me.
Thank you. So we're going to take a 5-minute break. I know we're moving on to the next topic, which is housing. But let's just take let's come back at 20F, please, committee, and we'll dive into housing. Okay, let's go off live.